Welcome to the Supreme Court podcast. You've heard a review of the judicial branch and learned about the federal court system. Now we are looking at the Supreme Court. Granted, many appeals courts run in a similar fashion when hearing a case, and state Supreme Courts also run similarly. But for this podcast, I'm specifically discussing the Supreme Court and how it works. The Supreme Court is the highest court in the U.S. Unlike other appellate courts, it has some original jurisdiction. This means that cases involving multiple states, foreign nations, or ambassadors go directly to the Supreme Court. All other court cases start at the district level and are appellate cases. The Chief Justice of the Supreme Court is John Roberts. He is Chief Justice because that was the position that was available when he was nominated for it. He is essentially the leader and presides over the cases the court hears. He also has some administrative powers, such as setting the agenda for meetings. However, the Associate Justices and the Chief Justices all work together to come to their conclusions on a case. He has no more power or sway there. The Supreme Court really focuses on interpreting laws based on whether or not they follow the Constitution. They hear many federal cases, but hear other cases when it involves a violation of the Constitution. They have the role of being the final say on whether or not something violates it, otherwise known as judicial review. The justices meet privately to decide whether or not to take cases, known as hearing cases. They may not always agree on a case to be heard for many reasons. Some of these are because some or all of the justices think that this is a state issue. Sometimes they decide that the person who is suing doesn't have the right to even sue in the first place. That is known as lacking standing. Other times, they feel it's not worth it to hear the case if they don't think the lower court decisions are wrong. Also, cases are sometimes not heard because the justices don't feel society is ready for them to make a final decision on it, and it affects the entire country. For example, there have been many court cases concerning gay marriage rights prior to the court actually deciding whether or not to take up the case. This is because gay marriage was a highly political issue, and sometimes the courts first wait to see what Congress does regarding these political issues. Lastly, cases are sometimes not heard because there simply is not enough time to hear all of the important cases that are presented. Once the Supreme Court decides to take a case, each side submits a summary of the case known as a brief. Other people with expert knowledge may submit what's called a friend of the court brief, which the court also looks at, but the main briefs the courts use as a way of making a decision come from the two parties who are actually arguing the case before the Supreme Court. Specifically, it's the lawyers who write the briefs. It's also the lawyers who participate in the oral arguments. They are usually experienced trial lawyers who are used to fighting cases in the courtroom. Since they often get less than an hour to present their cases, they must be succinct and clear in why they feel their side is correct. The justices ask them difficult questions in order to see if their argument holds up and to clarify certain information. Remember, this is not a trial court. There are no witnesses, there's no jury, just the justices listening and then asking lots of questions. Once the justices have heard the case, they discuss it in depth. This process takes a long time. If for some reason there is a vacant spot on the Supreme Court, this might happen after a justice dies in office, then there can be a tie vote. If this happens, the ruling of the lower court stands. When the court issues a ruling on the case, this ruling is quite in-depth so that the people understand why the justices made the decision they did. They describe their reasoning. This allows for people to use the case as precedent in the future and better explain why a new case relates back to an old one. Sometimes the ruling will point out gaps in the law that Congress might need to address. For example, as technology has changed the way we live, problems have arisen that involve privacy. The courts have ruled on how far the right to privacy goes, but Congress also should pass laws regulating new technologies. These rulings, called opinions, are very detailed. One reason that it takes quite a few months after hearing the case for a decision to be made on it. There are three types of opinions. The main opinion is called the majority opinion. If every justice agrees for the same reason, then that's all that's written. However, some justices may have come to the same conclusion on the case, but for different reasons. That's known as a concurring opinion. It's written so that we can understand that person's reasoning as well. Also, since often all 9 justices don't agree on the outcome of a case, there's also something called a dissenting opinion. It is also a detailed reasoning about why these justices, or one justice, came to the conclusion they did. The difference is that fewer justices agreed with their decision. The dissenting opinion can be very important because often this opinion can be used when laws are overturned years later. This will be explained in greater detail in a different lesson. As mentioned in a previous slide, the court often sets precedents for future cases. However, it's also important to note that the courts also rely on past precedents set in older cases to help guide their decision in the current case. They will often refer to many cases that were argued before the Supreme Court in the past, and other ones that had already been argued in lower courts. Thus, the court both looks at precedents and its ruling becomes a precedent that will surely be used in future cases with similar circumstances. Once a ruling is made and an opinion has been issued, that may be the end of it. The ruling stands and serves as future precedent. For example, once the court said that states couldn't make gay marriage illegal, the states had to issue same-sex marriage licenses regardless of the law in their states right away. Often, though, the case is remanded to a lower court. For example, if a person's rights were violated in their first trial, the Supreme Court may decide that the district, state, or local courts needs to retry them. They will have to start the case over. Sometimes it's not worth it for the government to bring charges again, so they don't bother. Other times there is a whole new trial and a person can actually still be found guilty in a criminal case or held responsible in a civil case. This does not violate the concept of double jeopardy, as we'll learn about when we study the Fifth Amendment. As I have shown, there is an established process that the Supreme Court uses in order to choose, hear, and decide on cases. Since the court usually picks the most important cases that have the most far-reaching effects, the outcome of these cases is super important and can affect society deeply. Due to past Supreme Court rulings, schools can no longer be segregated by race, women can choose whether or not to end their pregnancies, and states can decide for themselves whether or not to sentence people to death. These are just a few examples of the many ways the Supreme Court decisions have defined the way we live today. Thanks for listening. I hope you've learned something new today.